Welcome. I am going to begin to introduce the webinar, introduce ourselves while everyone comes in from the wait room, which looks like it's happening fairly quickly. But we really wanted to host this webinar today. It's intended primarily for Wisconsin parents. We want to talk about the recent changes to Title IX, how they might impact your child's school. We've heard a lot of questions, confusion about what can be done about these new rules if there are concerns about them. How do local, state, and federal kind of levels of government interact? And what to do with all of the different information that you might be hearing from different resources. So we hope that this joint webinar today by the Wisconsin Institute for Law and Liberty and the Southeastern Legal Foundation will help provide some clarity for you all, and not only educate you, but empower you to discuss these issues at the local level in your communities and give you some tools should you want to take action and talk about this issue, this Title IX issue. So with that, I will introduce myself a little bit more fully later on, as well as my colleague Luke Berg. But I am going to let attorney Kim Herman introduce herself and her organization, and she is going to kick it off for us. So thanks all for being here today, and I'll turn it over to Kim.
Awesome. Thanks, Corey. We're really happy to be with all of you here today. I hopefully, I can't see who's on this, but hopefully I've met some of you or that you've attended some of our webinars before. As Corey mentioned, my name is Kim Herman, and I am Executive Director here at the Southeastern Legal Foundation. We are one of the country's oldest conservative public interest law firms, which simply means that for almost 50 years, we have been suing the government when it violates your constitutional rights. We work in a variety of different issue areas, but I won't bore you with that today. We're just here today to talk about Title IX and the Biden-Harris changes that they put into place earlier this year. And so with that, I'm going to go ahead and I'm going to share my screen. I want to make just a few comments before I do that, though. I am not barred in Wisconsin, so really important. You've got some amazing Wisconsin attorneys on today. I am not licensed to practice law in Wisconsin. None of this is intended to be legal advice. We're just trying to help educate Americans on Title IX and on their constitutional rights. And we here at Southeastern Legal Foundation, we also represent Young America's Foundation and Moms for Liberty in a federal lawsuit that they have filed against the Department of Education, challenging these new regulations that we are going to talk about today. There is an injunction in place in that case, and I will mention that as we kind of walk through Title IX and what it is and what these changes are. So with that, I'm going to go ahead and share my screen so you guys don't have to stare at my face the whole time. There's something else to look at. Okay, if we're going to talk about any law, we always have to start with the text of that law because that is where the courts are going to start when they look at it. So Title IX of the Education Amendments of 1972. What does it say? It says, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. It's a mouthful, but it's actually really short as far as federal statutes go. And that's where we're going to start, is the fact that this is a federal statute that prohibits discrimination on the basis of sex. So when we say it's a statute, what we mean by that is that this is a law passed by Congress. It is not a rule that was put out by the Department of Education or a different federal agency. It is not an executive order. It is not a memo to the file. It is a law passed by Congress. And it was passed in response to the fact that girls and women were being excluded from educational opportunities. There were graduate programs that women just simply were denied access to because of the fact that they were a woman. There were schools that are young girls, there were athletic programs, there were extracurricular activities, right? The list goes on and on. The point of this was that everyone would have equal access to educational opportunities. When it was originally passed, we did not have regulations that came immediately with it. And when I say regulations, regulations are things that are implemented, so they are created, They are put out for notice and comment. So all Americans get an opportunity to comment on them and say, yes, you should do this, or no, you shouldn't do this. And then the federal agency will go ahead, finalize them, and then implement them. And they relate back to some law. Here, the law is Title IX. So in 1975, we saw the first major regulations come out with respect to Title IX that also implicated athletics. A lot of people think of Title IX as an athletics law. It was, again, to ensure the entire educational opportunity, that people were not discriminated against on the basis of their sex. And in 1975, the federal agency that was in place at the time, HEW, they went ahead and made sure that everyone knew that this also applied to athletics, and made sure that there were some nuances as to how schools were going to go ahead and implement and enforce Title IX with respect to athletics. During these early years, there was also something really important happening with Title IX. Congress and our federal agencies made sure that schools understood that having sex-separate facilities, so things like bathrooms, locker rooms, overnight sleeping accommodations, fraternities and sororities, that did not constitute discrimination on the basis of sex. They were specifically excluded from amounting to discrimination on the basis of sex. Now, why did they have to do this? Put yourself back 50 years ago. Title IX was not welcomed by all, okay? And we also have laws in our Civil Rights Act of 1964 and our Equal Protection Clause that prohibited things, as they should, like separate but equal in racial discrimination. So Congress and our federal agency had to make really clear that there was room for separate but equal to protect the dignity and privacy of our girls, women, and our boys and our men in those private spaces. That's going to be really significant when we talk about some of the changes that are happening today. So to continue on with our timeline of Title IX, in 1979, Congress creates the Department of Education. And the Department of Education is given the power to implement and enforce Title IX at all schools receiving federal financial assistance. There's a continued effort to cabin the protections that are afforded in Title IX. So we had some schools that might say, I'm just going to give an example. Let's say that they receive federal funding, and on their accounting, right, like in their statements on the back end, they would say, we're going to funnel all of that money to our med school, and our business school isn't going to get any of that money. So we only have to allow women into our medical school. We don't have to allow women into our business school. That was happening in places throughout America. Congress came in 1988 and they said, that is not what we intended. If your school receives any federal financial assistance, then all of your programs have to follow Title IX, right? Because Title IX applies to the entire educational opportunity. So he made sure that it was clear that it was institution-wide. So for the first 20, 25 years of Title IX, we see a continued strengthening of the protections for our girls and our women in our schools. In 1997, we start to see some changes happening at the executive branch level to Title IX. Again, Congress is the body that passed Title IX. Congress is where any major changes to Title IX should happen, not at our executive branch level with our federal agencies. But we saw a different picture starting to happen in 1997. Under the Clinton Department of Education, they issued guidance that expanded the scope of discrimination on the basis of sex to include sexual harassment. This is the very first time, right? If you look at the actual language that we looked at, you don't see sexual harassment anywhere in that statute. However, they didn't give us standards, and they didn't give us a way to know whether or not behavior actually amounted to sexual harassment. So confusion started to come into play. There, of course, were lawsuits filed across the board, across the country, and the Supreme Court stepped in and gave us what's called the Davis standard. The name of the Davis standard is only significant because we're going to be referring to it back as that when we talk about the changes in a few minutes that are happening this year. Under this Davis standard, the Supreme Court said you have to meet 1, 2, 3, 4, 5 if you want to establish a claim for sexual harassment, and you would defend yourself against a claim with A, B, or C, okay? It was an objective standard. That is the piece to remember at this moment in the presentation. The Supreme Court comes in 1999, gives us an objective standard to determine whether or not somebody violated Title IX through sexual harassment. The Department of Education, however, does not adopt that standard. So if you file a federal lawsuit saying that there was sexual harassment, you know what you have to prove. And if you're on the receiving end of that lawsuit, you know how to defend yourself. If a Title IX complaint is filed with the Department of Education for sexual harassment, it did not say that it was going to officially follow the standard put forth by the US Supreme Court. So there was still a lot of uncertainty with respect to Title IX and these sexual harassment claims that the executive branch had broadened Title IX to cover. In 2011, the Obama administration comes in and they issue a series of guidance documents. Again, these are not rules and regulations. They do not go through notice and comment period. There are three key ones that I want to draw your attention to today that are going to be relevant when we talk about the changes. The first is the Dear Colleague letter that created the so-called kangaroo courts. I did not give them that name. That is just what they are commonly referred to. This set forth a loose procedure for how the Department of Education was going to handle Title IX complaints that were filed with the Office of Civil Rights. Okay, they are called kangaroo courts because they largely deprived the accused of due process. There was not a right to defend themselves. There was not a right to cross-examine witnesses. There was not a right to see all of the evidence. There was not a right to talk about the complaint outside of the administrative process. So we saw a lot of things that you would normally get in a court process or in an administrative law process that are required by the Constitution that were not provided for in this grievance process. There was a lot of litigation that came out of this. In 2014, we get the next major guidance document, and that was a Q&A document. So again, just a memo to the file where the Department of Education announced that it was now going to include gender identity in the definition of sex for the very first time. We did not have Congress coming in 2014 and redefining sex. We did not even have a rule or regulation being put forth and published redefining sex. This was a memo to the file. In 2016, we get the third major memo to the file, which was the Bathroom Dear Colleague letter, where the Department of Education announced that in general, if a school does not allow boys who identify as girls to use the girls' bathroom and vice versa, that it could be subject to Title IX violation, and it could be putting its federal financial funding at risk. So first 25 years of Title IX, we went through it very quickly for time purposes, but we saw a strengthening of the protections that Congress put into place in 1972. The next 25 years, we see a lot of action by our executive branch and by our Department of Education, none of which went through the rulemaking process. And we see what I would characterize as an erosion of the protections that Congress put into place in 1972. So how did we get to where we are today? There was one thing that happened before we talk about the new changes, and that is that in 2020, we got from the Trump administration a new rule. This is the 2020 Title IX rule. This went through notice and comment. And what the Department of Education did under Betsy DeVos was adopt that objective standard that we saw in the Davis, that 1999 Supreme Court case I mentioned. This is why it's important. The Department of Education formally adopted the objective standard to go ahead and administer complaints for sexual harassment. And they also brought the grievance process back in line with due process as required by the Constitution. So we saw some major changes in 2020, again, going through the rulemaking process. They received, I forget how many comments. I think it was over 100,000 public comments that they received. So the public had a chance to weigh in, bringing Title IX back into line with the congressional intent and our Constitution. Earlier this year, I'm going to wait to go to the next slide. Earlier this year, in April 2024, we got the rules that we're here to talk about today, the 2024 Title IX rule. When President Biden took office, he gave his agencies basically an assignment through an executive order saying that they need to go through and provide protections for gender identity, right? So in other words, replace sex with gender identity in the various regulations that are out there. The Department of Education issued a notice of proposed rulemaking, and here they did go through the rulemaking process. They received over 240,000 public comments in response to its proposed rule, and in April 2024, they finalized it. The rule encompasses, with the responses to comments, encompasses 1,500 pages. We certainly don't have time to talk about all of the changes today. So I want to bring 3 of the key changes to your attention before kicking it to Corey to talk, and Luke to talk about Wisconsin-specific issues and how this relates to your state. So the first major change is a change to the definition of sex. So the Department of Education picked right back up from where it was back in 2014 with that Q&A document. And they did this through the rulemaking process, where they now changed sex to mean gender identity. Again, Title IX never mentions gender identity. The concept wouldn't have even been thought of in 1972. Congress has repeatedly tried to change the definition of sex to mean gender identity and failed. So what does gender identity even mean in the new rule? Well, quite frankly, your guess is as good as mine. The closest that we get to a definition of gender identity is that it is an individual sense of their gender, which may or may not be different from their sex assigned at birth. So a completely subjective standard. Schools are also very limited in how much they can question somebody's gender identity. So this is not a situation where they can say, okay, let's sit down with your parents and let's see a gender dysphoria diagnosis, right? Let's really work through this. Let's work with those that are treating you for this and see what the proper response here is. No, they have to take a child at their word, whether the child is 4, 16, 24 years old. Gender identity is completely subjective, which means that everyone else has to also guess as to what that person is thinking that day. It also expands the scope of sex discrimination. So in the very beginning, we said, what does Title IX say? It prohibits discrimination on the basis of sex. It now prohibits discrimination on the basis of sex stereotypes, sex characteristics, pregnancy or related conditions, which basically can mean abortion, sexual orientation, and gender identity. So greatly expanding the scope of Title IX and what is prohibited by Title IX. Again, this is being done by an agency and not by Congress. So you are taking the major word that matters in Title IX, sex, you are changing the definition, and then they are expanding the scope of what discrimination that can also reach. Things that Congress should arguably be doing, and the courts are agreeing on that point. The third major change that I want to bring to everyone's attention is a change to the standard for sexual harassment. So you may have been wondering why we were talking about a lawsuit, a Supreme Court case back from 1999 called the Davis case. Who cares? What does it matter? It matters a great deal, because when we're talking about the standard, this is what a court is going to look at. This is what the Department of Education is going to look at when a Title IX complaint is filed with its Office of Civil Rights to determine whether or not a violation occurred. Under the Davis standard that is in place under the Betsy DeVos 2020 Title IX rule, a person needs to establish that there was unwelcome conduct that a reasonable person, there's that objective standard that I mentioned, a reasonable person would determine is so severe, so really bad, pervasive, happening a lot, and objectively offensive that it effectively denies a person equal access to education. So you're looking at the entire educational experience, and you have severe, pervasive, and objectively offensive. Under the 2024 rule, the standard is unwelcome sex-based conduct. So we already have a change there, because under the new rule, sex does not mean sex. Sex means gender identity, sex stereotypes, sex characteristics, right? The list that we went through on the prior slide. So unwelcome sex-based conduct that is subjectively and objectively offensive. So we now have the imposition of the word subjective in there. And the courts that have looked at this throughout the country have largely said that the subjective is going to swallow the objective. So we are now looking at, for all intents and purposes, a subjective standard, okay? So unwelcome sex-based conduct that is subjectively and objectively offensive, that is so severe or pervasive that it limits or denies a person's ability to participate in a benefit or an educational program or activity. I want to give you one quick example. Let's say you have a 15-year-old daughter who is required to change for PE. She goes into the locker room and starts changing. A boy comes in that locker room saying that he is identifying as a girl that day. He simply wants to change, or he simply wants to change in the girls' locker room. He starts undressing, and your daughter says, "Please don't change in front of me," or "This makes me uncomfortable," goes to the coach and says, "I don't want to change in this locker room if a boy is changing and undressing in front of me." That boy feels that that is unwelcome sex-based conduct because she's either making a comment about his sex characteristics, his body, or his gender identity. He is subjectively offended. He believes that it's so severe that he now cannot change for PE, and he is required to change for PE just like she is. He now has the ability to file a Title IX complaint against your daughter for saying that she felt unsafe or didn't want to undress in front of a biological male. And she now has to defend herself against that Title IX complaint. Completely turning Title IX on its head, right? Title IX should be protecting the girl in that space from ensuring that she has privacy and dignity to change and participate in PE that day. Under the old standard, you were looking at equal access to education, not just one class in one day, right? So this has really, really reduced the bar. And I know that Corey and Luke are going to go into some real world examples of clients that they are representing that are facing similar situations. The other big change is that it ends sex separate programs in private spaces, not just through a First Amendment violation, but it also ends them by changing the standards. It tells schools that they can have these sex separate programs in private spaces that Congress ensured exist only if they create no more than a de minimis harm. And then it goes on to define that by saying that you can't subjectively offend somebody based on their gender identity. And so again, the courts that have looked at this, especially I believe it's the court in Tennessee and the court in a lawsuit that we have filed in Kansas, have done a very thorough job of analyzing this provision in their opinions. And so I would point you there if you have any more interest in it. For sake of time, I'm just going to quickly tell you about the injunction that exists in the lawsuit. I'm going to stop sharing my screen here. Quickly tell you about the injunction that exists in the lawsuit that Moms for Liberty and Young America's Foundation have brought, so you understand the scope of that before Corey and Luke talk about how that's going to apply in your state. So in the lawsuit, the federal district judge has issued a preliminary injunction on the Department of Education. The injunction says that the Department of Education cannot implement or enforce these new changes that we talked about, or any new changes set forth in the 2024 rule at any school attended by a Young America's Foundation member, or any school attended by a member, a child, excuse me, of a member of Moms for Liberty. Okay. It then said, I need to know where those schools are. Otherwise, I can't enforce the injunction, and the Department of Education really can't abide by it because they need to know where these schools are. So give us notice of those. And so we have periodically been filing notice with the court just to let them know where those schools are. The injunction does cover automatically, though, all of the schools attended by children of Moms for Liberty members and Young America's Foundation members. There's a process to get your schools on the list. If you don't know how to do that, you are welcome to contact myself, and I will get you in touch with some of those organizations. So with that, I'm going to go ahead and kick it to Corey so we have plenty of time to talk about Wisconsin specifically and plenty of time to answer your questions.
Thank you, Kim. Quick reminder, if you have any questions about what Kim just shared or about anything that Luke or I will share, there is a Q&A function at the bottom of your screen. Feel free to use that at any time as you think of questions. I also wanted to share, and I apologize for not sharing this in the beginning. Hopefully not too many of you were furiously taking notes during that, but this will be made available on our YouTube page, on the Wisconsin Institute for Law and Liberty YouTube page. And then for everyone who has signed up, you'll also receive a link tomorrow once everything is uploaded. So for anyone who doesn't know me, my role here at Will is Education Counsel. I work on legal and policy issues related to K through 12 education. And once I provide a little bit of an overview here, I'm going to be turning it over to my colleague Luke Berg, who is Deputy Counsel here at Will. Now, before I get into the overview about kind of the various levels of government and what to know about how they work together and kind of the hierarchical system that you should be aware of, I wanted to mention, in case there are any leaders of religious schools, parents whose children attend religious schools, I just wanted to mention for you all that Title IX does allow for exemptions from its provisions for entities with religious objections. That was not changed from the previous rule. The rule that was finalized in April and went into effect on August 1st, that has not changed. So by its plain terms, Title IX, quote, shall not apply to an educational institution which is controlled by a religious organization if the application would not be consistent with the religious tenets of such organization. So if anyone has questions about that, if you need a citation, if you have any more detailed questions, feel free to reach out to us directly. Now, before I turn it over to Luke to talk about Wisconsin law, I just want to talk about the different levels of government that you all should be aware of. And probably a lot of you know all of this, but we thought it would be a good thing to just go over first. So starting from the basics, there are 3 levels of government: national level, state level, and local level. In this context, when we're talking about the local level, we're talking about school boards. Beyond those levels, there's also different branches to know about. Those are the legislative branch, the executive branch, and the judicial branch. Now, I'm going to start from local, state, and then make my way to federal, and then I'm going to mention the courts as well. But I know we have a few individuals on this call who are not from Wisconsin. This section will focus specifically on Wisconsin, but I would recommend that you just look up your applicable state law as well. A lot of states have very similar provisions, so it's something to check with your any district legal counsel. If you're a parent, just do a little bit of research. There's often very similar laws. But the default rule in a school district is that school board runs the school district. So they get to make decisions about policy. Obviously, they have to follow state and federal law. They shouldn't conflict with it. But beyond that, they get to make this policy. And in Wisconsin, where does that authority come from? I just would like to go over this fairly quickly. Our state constitution in Wisconsin says that the supervision of public instruction shall be vested in a state superintendent, and such other officers as the legislature shall direct, and their qualifications, powers, duties, and compensation should all be prescribed by law. That's in Article 10, Section 1. So what's prescribed by law? If you turn to the Wisconsin state statutes, Section 110(12), school boards are granted broad authority to exercise their duties and powers. So school boards have significant control, allowing them to directly provide for the education of children, while also delegating some authorities to others, such as the district administrator or superintendent. So in doing, quote, all things reasonable to promote the cause of education, the duties of Wisconsin of school board members are listed in that section of our state law, 120(12). Now, beyond duties, there's also powers. So Wisconsin law sets forth over 40 specific powers of school boards. For example, just a few that are included there are the power to make rules for the district, suspend and expel students, make purchases, provide meals to students, contract with governmental units, lease property, sell property, and more. So that's kind of an overview of the authority that a local governmental entity such as a school board has. Now, I mentioned that when districts make policy, it shouldn't conflict with state and federal law. So what should you know about state laws when it comes to education? Just very generally, states have some flexibility in how they administer and implement federal laws. State legislatures pass laws at the state level. State educational agencies may go through the rulemaking process to promulgate administrative rules, and they often issue guidance as well to help the local entities with the federal regulations. Here in Wisconsin, our state educational agency is the Department of Public Instruction, or DPI. Sometimes state policies conflict with federal rules. Often that resolution of that involves legal challenges, and it might involve delayed enforcement. I don't want to get into too much detail there. Luke will talk a little bit more about the legal aspects to be aware of. So I'll just turn to federal law. Again, each power of Wisconsin school boards is subject to limitations based on state and federal law and the Wisconsin and United States constitutions. At the federal level, Congress in general sets policies that are more broad than education policies you might see at the state or local level. Examples might be the Every Student Succeeds Act, or ESSA, Individuals with Disabilities Act, the IDEA. Title IX is an example of that. And executive agencies like the U.S. Department of Education, they can issue rules and regulation to implement the laws passed by Congress. Now, I want to be clear here that there have been legal arguments made in federal lawsuits across the country that the rule finalized by the Department of Education in this case in Title IX actually conflicts with the law passed by Congress and is therefore unlawful. So that is being litigated right now. And as Kim mentioned, just to bring it back to Title IX, that's a law passed by Congress, prohibits sex discrimination in school districts. Really, it says any educational program or activity receiving federal financial assistance. And the new regulation adopted by the Biden-Harris administration implements the Title IX law, or intends to implement the Title IX law that was passed by Congress. That rule was finalized last spring. It's facing a lot of legal challenges. It makes some significant changes from the prior regulations, as Kim discussed. And Will has a resource available on what school boards should know about the new Title IX rule. We are also working on a more detailed resource. It's forthcoming this fall. It will be co-authored with Southeastern Legal Foundation and the Defense of Freedom Institute. That'll be a deeper dive resource, again, for school boards, but we hope that it will be informative for anyone who's interested in the topic. So again, parents should understand how these new federal rules could impact their child, stay informed about changes at all levels of government. You're here today, getting informed today. So again, follow any updates from the school district, and then hopefully you can advocate for your child's education, engage in community discussions. And before I turn it over to Luke to talk about Wisconsin law specifically, I just want to go through an overview of the federal court system. I think this is probably even more than the 3 levels of government. This is really important to our discussion here today. Federal court system, again, 3 levels. We have the United States Supreme Court at the top. District courts are the lowest level, which are all over the country. Here in Wisconsin, we have the Western District in Madison and the Eastern District in Green Bay and Milwaukee. In between those 2 levels, so in between the United States Supreme Court and the district courts, are the courts of appeals. The country is divided into circuits. We in Wisconsin are in the 7th Circuit. The 7th Circuit covers Wisconsin, Illinois, and Indiana. So the courts have a hierarchy, essentially meaning that what an appellate court says is binding on district courts, and what the United States Supreme Court says is binding on all lower courts. So with that general kind of understanding and framework of how the federal court system is set up, I will turn it over to Luke. And again, if you have any questions, put those in the Q&A function.
All right, thank you, Corey. She said I'm one of our litigating attorneys here at Will, so I'm going to be talking about the state of the current litigation in Wisconsin over, in particular, the bathroom issue and how it relates to the new rule. And it's a bit complicated, so we have to, unfortunately, educate you and give you some of the sort of foundational pieces that you need to understand the current state of the law in this area. So as Corey mentioned, there's 3 levels to the court system: district courts, the courts of appeals, and the United States Supreme Court. The Seventh Circuit in 2017 heard a decision called Whitaker, and it was filed against the Kenosha School District. You've probably heard about this case. This was a case brought by a transgender student who wanted access to the opposite sex bathroom. And that student won their case. So they won at the district court. It got appealed to the Seventh Circuit, and the student won at the Seventh Circuit. And the takeaway from the decision was that the school district had to allow that particular student to use the bathrooms of the opposite sex. So when your school districts and people are talking about this issue, you're going to hear this case thrown around quite a bit and talked about quite a bit. And there's a lot of misinformation or incomplete information about what that case said and what it means. So that's kind of what I'm going to explain. So in a typical case, you file the complaint and, then each side gets to do discovery and put together their evidence. And the whole process takes 6 months to a year, if not longer, before you eventually get a final ruling from the district court. But there's a way to abbreviate that process. So if you think that you need immediate relief, you can move for what's called an injunction. And that all happens on a very quick abbreviated schedule. So that's what happened in the Whitaker case. This student filed their complaint, moved for an injunction, and said, I want an order from the court immediately saying that I get access to the opposite sex bathrooms. So the student won the injunction. The school district immediately appealed the injunction. And so that's the posture that the case got before the Seventh Circuit in. The reason that's relevant is the school district and the parties didn't have a full opportunity to put forth a full record. And so the Seventh Circuit was analyzing the decision just based on the facts that it had before it. But one of the criteria for an injunction is the student likely to succeed ultimately in their claim? And that's where you get the language. The Seventh Circuit said, yes, the student is likely to succeed. And there's language in there suggesting that the Seventh Circuit thought that Title IX requires school districts to allow transgender students to use whatever bathroom they identify with. Now, importantly, this case was brought before the new rule. This was back in 2017. So this was under the old Title IX rule. And under those old rules, the Seventh Circuit said, yeah, we think Title IX likely requires the school district to allow this student to use the opposite sex bathroom. Now, I think that decision was wrongly decided. I think that's a misinterpretation of Title IX, but that is what the Seventh Circuit said. And that's a binding decision on lower courts in the future and has been since 2017. Now, since Whitaker was decided, other circuits, other federal courts of appeals have weighed in on the issue, most notably the 11th Circuit, which covers Alabama, Georgia, and Florida. And the 11th Circuit went the opposite way. And it said, no, we think very clearly Title IX can allow school districts to limit bathrooms based on biological sex. So there's now what we lawyers like to call a split in the country where different circuits disagree on a legal question. And so eventually the US Supreme Court is going to have to weigh in on this. But I do think the reasoning in the 11th Circuit case undermines the Seventh Circuit a bit, the Seventh Circuit decision in Whitaker a little bit. Now, one of the other things you need to know about Whitaker is because it went up in this sort of preliminary posture, it wasn't even a final decision in that particular case, nor did the language in the case was it so universal to say in every situation with every student ever, school districts always have to allow any student who asserts a transgender identity to use the opposite sex bathroom. The court was only considering the particular facts before it. And there's lots of things that you could think might matter, right? The age of the student could matter. One of the things that the Seventh Circuit emphasized was the distance that the student had to walk to use sort of a neutral alternative bathroom in the school district. You can think how well documented is the gender dysphoria, right? There's just a lot of different facts that you think could matter to the outcome of a case like this. And this is the kind of thing that lawyers do all the time. In future cases, they distinguish prior cases. So They compare their new case to that prior case and say, well, our bathrooms are closer, the student is, younger, whatever. So there's lots of different ways to distinguish cases, especially when it goes up on a preliminary posture like this. But that case has been in place since 2017. So since then, there's been a number of cases where school districts have attempted to do exactly that. They've tried to distinguish Whitaker in a similar case, same basic posture, a transgender student who wants access to the opposite sex bathroom. And the school district says, we think our case is different for X, Y, or Z reason. There have been probably 5, 6, 7 or so cases, maybe more, but that's how many that I'm aware of in the Seventh Circuit, where school districts have tried to distinguish Whitaker. And in every single one of those cases, the school district has lost so far. One of those cases went back up to the Seventh Circuit recently, just in the last year. The case is called AC versus Martinsville. And the school district had a bunch of arguments for why they thought the outcome should be different. They lost at the Seventh Circuit, but this time they lost sort of 2-1. So when you have an appeal with the Seventh Circuit, there's a pool of judges, and you get 3 randomly. And as you can imagine, different judges disagree about the reasoning sometimes. So in the next case that went up, again, the school district lost. And the court said, nope, we're going to stick with our prior decision from Whitaker. We think that the old Title IX rules require school districts to allow transgender students to use the bathroom that they identify with. One of the judges said, I actually think Whitaker was wrongly decided, but I think this is an issue that the Supreme Court is eventually going to have to weigh in on. So the school district in that case tried to get to the United States Supreme Court, asked it to take the case. Because there's a split now with the 11th Circuit, I think everybody who was watching the case thought that the US Supreme Court was going to take it, and then they didn't. They denied review of the case. And I'll get to why I think that is in a moment. But what that means is, for the time being, for any school district that is in the Seventh Circuit, so Illinois, Indiana, or Wisconsin, Whitaker and that AC case are the binding precedents on trial courts. So if a new school district has a policy that says we're going to limit bathrooms based on biological sex, and a transgender student sues the school district over that and says, I want access to the opposite sex bathroom, the bathroom I identify with, the trial court is going to look at those 2 cases, Whitaker and AC, and going to say, I am bound by the Seventh Circuit, which is above me, and they have twice now said that Title IX, the old rules, requires school districts to allow these students to use these bathrooms. So I'm bound by that, and I'm going to come to the same outcome in this case. Okay. So for the time being, the prospects are not good for school districts in Wisconsin, Illinois, and Indiana who disagree with that outcome. That's what you're frequently going to hear. We've heard a lot of school boards and school administrators saying, even though the new rule has been enjoined, as Kim talked about, this is the law of the land. We have to follow it, and we have to implement this new rule anyway because Whitaker and because Martinsville. Now, that's inaccurate for a few reasons. So one thing to understand is Whitaker and AC is only about the bathroom issue, okay? That's the only issue that was presented to the court in both of those cases. The new rule, as Kim talked about, covers a whole lot more than the bathroom issue. So while it's true that Whitaker and AC are binding precedent in the Seventh Circuit on the bathroom issue, they have very little relevance to the rest of what's in the new rule, and that's a lot. And so if your school board or your superintendent is saying, we need to pass all of these sweeping changes to the sexual harassment process and all the other stuff in the new rule, even though it's been enjoined as to our school district, that would not be a true argument or the correct thing legally, because Whitaker and AC only apply to the bathroom issue. Okay. The other thing that makes the argument, even with respect to the bathroom issue, not a complete picture, is that the new rule is premised on the same foundation as the logic of Whitaker and AC. So Whitaker and AC's basic premise of their holding was that Title IX, the pre-existing rule before the new rule, required schools to allow transgender students to use the opposite sex bathroom. That is now explicit in the new rule that's being litigated all over the country and that's been enjoined. The new rule says very clearly that school districts have to allow transgender students to use whatever bathroom they want. I think that is actually why the US Supreme Court denied cert in the AC case, as I mentioned. The school district in that case, that was their argument to the Supreme Court why it shouldn't take the case. It said this rule is about to change. The new rule is going to clearly address the bathroom issue. And so, court, there's no reason for you to weigh in now, because if the new rule survives, that will be the law of the land. And if it doesn't, that will be the law of the land. As Kim mentioned, there has been a lot of litigation over this new rule. There's 9 or 10 cases. Every single one of them so far has won against the new rule. Every lower court, except for one district court, to review it, has said that this new rule is actually unlawful and violates the statute in Title IX. None of those cases currently are in the Seventh Circuit, but the cases are all proceeding very quickly up the court system. There are multiple of the cases are already at the appellate level. And when it does eventually reach the United States Supreme Court, whatever it says about the issue, in my opinion, is very likely to decide the question one way or the other. So if the US Supreme Court says the new rule that changes the rules with respect to bathrooms is unlawful and actually violates the statute of Title IX, that rationale, once the US Supreme Court says that, is very likely to, what we say in the legal world, abrogate Whitaker and AC and undermine their precedential value, in which case they will no longer be binding on school districts. So it's sort of a time delay issue here. And the other piece of good news that everyone should be aware of is one of these cases against the new rule already went up to the United States Supreme Court in a motions posture. So I have to sort of explain how it went up. So like in Whitaker, all of these cases have sought injunctions against the new rule. Injunctions have been granted against the new rule in every one of the cases. In one of the cases, the federal government went to the US Supreme Court and said, we would like you to limit the scope of the injunction. We want the injunction not to apply to all of the provisions of the new rule, but only some of them. The United States Supreme Court denied that request, so the injunction continues to apply universally. The whole rule is enjoined. And that decision was a 5-4 decision from the United States Supreme Court. But notably, all 9 of the justices agreed that the bathroom portion of the new rule should be enjoined. So the 4 who dissented and thought we should limit the injunction in part, they said, we agree that the bathroom portion should be enjoined. We just think the rest of it, in particular, the process for sexual harassment charges, should not be enjoined. Now, that's notable because that's all 9 of the US Supreme Court justices. So that is a strong signal on how this case is ultimately going to turn out when it reaches the United States Supreme Court. Now, that decision is not a binding precedent in the sense that it currently undermines Whitaker, but it certainly undermines Whitaker. It doesn't overrule Whitaker yet because it wasn't a final decision. It was just a decision on a motion. But it's a very strong signal that Whitaker is on thin ice and is not likely to be precedential in the future. So putting that all together, one of the questions that we frequently get from people about this is, do we actually have to adopt this new rule in the meantime because Whitaker? And the answer with respect to anything but the bathroom issue is no. Whitaker only dealt with the bathroom issue. The answer with respect to the bathroom issue is if your school district gets sued over the issue, for the time being, it's very likely to lose the litigation, given that Whitaker is still a binding precedent. But in the very near future, Whitaker is likely to go away. And if the outcome is what everyone, I think, expects it's going to be, then the school district will likely win. So again, this is all prediction based on the moving a moving field where it's actively being litigated. So I think it's very fair for a school district to say, we're just going to hold off for the time being and watch litigation. Obviously, we'll follow the law, whatever it is, once this shakes out, but it's currently in the process of being litigated, and we still don't know what the outcome is going to be. The other thing that I think might answer a question that a lot of you have, what we've been hearing from a lot of people, relates to the injunction, specifically the Moms for Liberty injunction. People think, doesn't this prevent my school district from adopting the new rule or changing the new rule with respect to bathrooms? And the answer is no. So what an injunction does, what the Moms for Liberty injunction does, is it stops the U.S. Department of Education from enforcing its new rule against school districts. But there's sort of three different possibilities that you talk about when you talk about the bathroom issue. There's you must, you cannot, and you may, right? The existing Title IX rules, pre-existing the Biden-Harris administration's change, said you may have sex-separated bathrooms. The new rule from the Biden administration says you must allow transgender students to use whatever bathroom they identify with. By enjoining that, you don't move to school districts may not allow transgender students to use opposite sex bathrooms. You move back to may. And so that really allows school districts to decide for themselves how they want to deal with this issue. And if there's a school district that says, yes, I know that the Department of Education has been enjoined as to our school with respect to even the bathroom issue, but we want to adopt that policy. We want to allow transgender students to use whatever bathroom they want. They can do that. There's nothing that stops them from doing that. But the advantage of the injunction is it sort of puts the onus and the blame on the school board, and so that the public can be aware that they're doing it voluntarily and they're not forced to by the new rule. So I hope that answers some of your questions. We still have 5 minutes to address a little bit of the Q&A. Maybe my colleagues, Kim and Corey, can pop back on and we can answer some of the questions. So I'll cut it off there.
Thank you, Luke. I see one here that I would like to respond to, and then perhaps Kim can weigh in with regard to the case that SLF is litigating. And one of these questions here is about the rule not being the law. And this is something that I've heard before as well. And the only thing I would emphasize is that even though it isn't a law passed by Congress, a federal regulation, as long as the appropriate rulemaking process is followed and the proposed rule is finalized, it does have the force of law. So these executive agencies, they don't make law, but they implement the law. And if they go through that process, which it did happen here, there was notice of proposed rulemaking, the comment process took place, there were a record number of comments submitted that had to be reviewed. The rule was finalized in April of 2024, and it went into effect on August 1, 2024. So even though it's not a law passed by Congress, it does still have the force of law, even though we think that it is unlawful on several grounds. So I don't know, Kim, if you see any questions, Q&A to respond to.
Yeah, I think, oh, sorry, my screen was frozen there. I think that there's a couple, and just one thing to add on to what Corey said is, yes, it is a law it's a rule with the full force and effect of law, but that doesn't mean that the Department of Education actually had the authority to do what it do. So one of the issues that is relevant in a lawsuit and that courts are saying is that because the definition of sex is such a major question, it's such a major component to the law, that only Congress has the authority to actually change that definition, and that the Department of Education took that power for itself that it doesn't actually have, right? And so anyway, so when we talk about that, it doesn't mean it doesn't have the full force and effect of law, but the courts are going to decide whether or not the Department of Education could even do this in the first place. So there's a bunch of questions that I saw that are all very kind of similar, and some of it has to do with the list. So question is, that a few people have asked is, when is the next list going to be filed with the courts? I don't know exactly. We have a lot of stuff going on with an active litigation. So the Department of Education has appealed the preliminary injunction. The 10th Circuit is looking at that. We are moving forward in the district court, briefing on the merits and trying to get a permanent injunction there. And so based on all of those deadlines of all of the parties involved, we have to make some strategic decisions about when to file that list. The last list was filed on August 28th. I'll put in the chat where you can find all of those lists. And so sometime in the end of September, beginning of October, you'll probably see another list. The important thing to remember is that if you are a Moms for Liberty member, your school is under that injunction. We do have to give the court notice. We do have to give the Department of Education notice, but it doesn't mean the injunction only extends to those schools. It's some very nuanced legal stuff that's going on, right? These are very intense strategic lawsuits. That, as Luke mentioned, there's a lot of legal procedures that go on with this. So we just ask for some grace as we actually get to litigate this case to ensure the broadest protections for all of our parents and all of our kids throughout the country. Okay, so we just ask for a little bit of grace there. Another question was about grandparents. I get this a lot, grandparents, aunts, and uncles. This applies to parents or legal guardians that are Moms for Liberty members. So just because you're a taxpayer and pay into the tax system, or just because you're a grandparent and you care very much about this issue, that is not who the injunction extends to. Okay, so we need to be really mindful with that. If you don't know how to update your Moms for Liberty profile, I encourage you to reach out to a Moms for Liberty ambassador, Bill Brewer, Scarlett Johnson. They are Moms for Liberty ambassadors. You can always reach out to Will. They can get you in touch with one of them. Reach out to us. We can get you in touch with one of them, and they will show you how to do that. That also brings me to one other question. I know I'm talking a lot and talking fast. I want to be respectful of your time. A question that we've gotten that's on here is, who do I call if there's a state law issue, right? As you can tell, we work very closely with Will on many, many issues that expand far outside of the K-12. If you come to us with a state law specific issue, we are most likely going to send you over to them because it's likely something that we cannot handle. If we can handle it, we may partner with them to help you. Otherwise, I would say call Corey, call Luke, work through their legal inquiry process, that you are going to be in best hands working with them on the ground for how to best handle one of these state law issues, okay? And so it's not that we don't want to handle it. We want to get you to the best attorneys that can help you with that particular issue. If it's not us, we want to help you find them. So I just want to make sure that you guys don't feel put off if we say we can't help you, and that you also know who you, sorry, I have a fly, that you can go to. I think that answers a number of the questions that are in here. Corey, do you see anything that you want to address? And then maybe we talk really quickly about the OCR issue. I'd love to talk about how that relates to the lawsuit, but there are a few state questions in here that you probably want to address first.
I do see, I'm scrolling down to the bottom here. So I do see one question that says, if our district voted on this, does that mean it's decided? It doesn't get brought up again? No. So if your district voted, no, we don't want to change our policy right now, it could still get added to the agenda again. We've also heard from school districts that did implement the new policy. Then there was some community pushback, or maybe the school board members learned more information, whatever it might be, and have said, actually, I don't think this is right for our community, and we might want to see what's going on with the litigation that's ongoing. Similarly, they could vote again. It could always get added to the agenda again. Some school boards have practices that once they pass a new policy or vote on something, it doesn't come back for another year or whatever it might be, but that's not in law. So they could always vote again one way or the other. One thing I want to mention about the recent Kettle Moraine federal complaint that was filed, and I'll let Luke weigh in on this as well, but I want to mention that it's not a lawsuit. It's a federal complaint with the Office of Civil Rights. So that is something that our prior resource addresses in terms of what that process looks like when such a complaint is made, and how OCR decides if they're going to open an investigation or not. And if OCR were to find non-compliance with applicable regulations, yes, worst case scenario could be the loss of federal funding if your school is not subject to an injunction. But that hasn't happened in the 50+ years that Title IX has been in place. Usually there's some other agreement that schools are able to come to with the federal government. That's not to say it couldn't happen. But if you're under an injunction, then the federal government cannot implement or enforce this new rule against your school under that court order that Kim mentioned. And the other thing that I would mention is that there's risk on both sides of this issue. Really, we're watching this all play out in court right now. So on either side of the issue, an OCR complaint could be filed, a lawsuit could be filed. And a lot of it's, and this is kind of a typical lawyer answer, but it depends. We're going to have to wait and see, and we're going to have to follow this. And it's something that Will and our friends at SLF are following and sharing updates on as we see new developments.
I just wanted to respond to a couple of the questions that dealt with the stuff that I talked about. I think I answered them, but it's just helpful to reiterate. So Cynthia Otten has a question. The school district attorney told the school board they do not have to abide by the injunction, and even went as far as to advise them not to. Is this accurate? Do they have a choice to abide by the injunction or not? So that's partially true. The injunction doesn't apply to school districts in the sense that it prevents them from adopting voluntarily the Biden administration's rules. So they could adopt it if they want to, but it does prevent the school board from asserting that they have to, right? So if the school board says we have to adopt the new rules because they've been passed, the injunction prevents that. And so it undercuts that argument and prevents them from hiding behind that. So I hope that makes sense and is somewhat clear. But what we hope is that this puts power in the public and in parents who can then push against this and say, you don't have to do this anymore. The injunction has freed you, and you shouldn't for all of the following reasons. But ultimately, it's the school board that decides what policies it adopts in the school district.
Yeah, I mean, and just to go along with that, just a couple of kind of points that I want to further make is that a question that we get a lot from parents in states like Wisconsin, especially in the Seventh Circuit, down in the Fourth Circuit in North Carolina, Virginia, Maryland, is, well, who cares about this lawsuit? Like, what's in it for me, right? In that sense, and I get that, right? I've got a 7 and a 10-year-old. That's why we're all in this fight. When we went through the history, it was also important because when we talk about what rule applies to your school, right? The 2020 Title IX rule is the rule that the Department of Education can implement and enforce at your school if your school is under the injunction. That means that if a Title IX complaint is filed in your school, let's say your daughter is the one in the locker room who says, I don't want to change in front of the boy, and a sexual harassment claim is brought against them, the Department of Education is under the 2020 Title IX rule grievance process. So your daughter has due process protections, or if your son is in college and he is a YAF member and his school, let's just say his school is under it, there are due process protections because they have to follow that grievance process and they have to apply the Davis standard. So there are huge protections. It may not be able to, necessarily change what your school has to do under state law for a bathroom. But if a complaint is filed, they are following the 2020 Title IX rule. The Department of Education is prohibited from following the new grievance process and the new standard when it actually looks at that Title IX complaint. That is a huge protection that your kids and your school will get as we get to fully litigate this case. And so hopefully that also helps just understand why this case is so important on the ground. So I just wanted to make that point. And I think it answers some of the questions that were in here. Are there any other questions that you guys see in here? I think we've covered a large majority of them. I know we're past time and people probably need to get to lunch. But Corey, if you see something that I should be answering that you think would be helpful, please let me know if I missed something.
I see a lot of specific questions. If we're able, and I know Eric has been sharing a few resources in the chat. if we're able to answer any of these, and again, I said there would be a follow-up email probably tomorrow with a link to this recording, and we'll share those resources. If there's anything we didn't touch on here that is more than a very district specific issue, we will include that in the email as well. There's nothing, I think we've been through most of them.
And I would just say that, if your school, if you're a Moms for Liberty member and you think that you did select your schools on your member profile and it was before August 28th and they have not shown up on the list, please reach out to IT support at momsforliberty.org. That is out there in the FAQs, which has been put in the chat by Eric, and they can help figure out what happened. Maybe it wasn't saved properly, things like that. So that's who you should reach out to for that. And if you are not a Moms for Liberty member, but you want to have your school covered by the injunction, there are ways to sign up for that. You can go to the website, and I think it's click join the fight, and that's how you can become a Moms for Liberty member. Or if you have kids in college, or in K through 12, they can also become YAF members, and then they would be included there. So lots of ways to get your school covered.
I do see one more here that I just want to respond to, and I know we're over time. If anyone has to leave, that's okay. But one thing I wanted to respond to, and then I'll let Luke, comment if we have anything else before we wrap up. But someone asked what happens to the other child's rights when they have to have an opposite sex individual in their bathroom. Presumably, this would mean a girl that has a boy who identifies as a girl in their sex separated facility. The one thing that I do want to add is, even though Will is not representing a party in any of the ongoing litigation challenging the Title IX rule, we are weighing in as amicus or friend of the court, and kind of weighing in several of these cases to say, hey, here's another story and some more legal authority for why we think this rule is unlawful. That's available on our website. It's actually a client that we have from the Sun Prairie School District. I'm not going to go through the whole story here because it's all available online, but we really wanted to get her story in front of the courts, because when she was a freshman, she and 3 other freshman girls in the girls' locker room after a swim unit and gym class, they went to rinse off. They had their swimsuits on, and they had a transgender individual, an adult male student who had not transitioned surgically or medically, shower fully undressed right next to them. That individual said, "I'm trans, by the way," and proceeded to shower right next to them in the girls' locker room. And we wanted to get that story in front of the court, because there actually is a lot of legal precedents for respecting the privacy rights of individuals, especially when it's minors, when it's young girls. And if this new Title IX rule, if the Supreme Court allows it to fully go into effect and basically says, no, we think this is fine, which again, I'm hopeful that doesn't happen. We've been fighting against it. We think it's unlawful. So far it's been successful in the lower courts, but if it were to go into effect, that situation would become not just common, but that would be required, would be to allow students of the opposite sex into those sex separate facilities. And we do think that's problematic, and primarily from not just the fact that the rule conflicts with the federal law passed by Congress, but just logistically the privacy rights of students as well. So I just wanted to touch on that, mention our involvement before we log off. But before that, Luke, do you see anything else that you would like to respond to?
No, I wish we had lots more time to talk through all of the questions in here, but we don't. So just feel free to reach out to any of us if there's something in here that wasn't answered. We've been having lots of conversations with people about these issues throughout the summer. So as Corey said, we'll send out an email summarizing this. You'll have the video, but if there's anything you feel like wasn't covered, feel free to reach out.
Thanks everyone for joining today. Thanks,
Bye,
Kim.
y'all.